Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulu Hoyan. I have this morning for you two possible solutions, open to the defense when the trial resumes. We know that on May 5th, the case has been set down what is known in law as fomention. In other words, Advocate Munisi will just tell the court how ready he is or how he is not ready to proceed with the case. And I think the case will then be postponed to the 19th, 2 weeks later, to resume properly. But I've got my own solutions, given the many challenges around this trial. The first solution is a Section 174 application. A Section 174 application goes this way. At the close of the prosecution case, if the prosecution is of the view that there is no case to answer, in other words, the prosecution witnesses have not made out a case sufficient enough to warrant an answer from the accused, and a 174 application can be made for the discharge of the accused at the stage of the trial. This is nothing new. In the Jocelyn Smith case, a similar application was made for the discharge of the accused, and it was rejected by the court. So getting back to the Meyiwa matter, at the close of the prosecution case, and the prosecution case is just about to close, so that will not be very far away, the defense has to mount a Section 174 application for the discharge of the accused. Because given the nature of the evidence that has been led in that court, that will give us a good idea or good indication whether there's really a case to answer. Because in the event that the court rejects the 174 application, this will give the defense a clear indication of where the court is going. Because the court in its rejection, and I'm not saying the court will reject that application, I don't preempt court judgment or decisions. In the event that the court rejects that 174 application, the court will then say it is rejecting that 174 application because of the following evidence tendered by the prosecution witnesses, which the accused have to come into the box for and challenge or rebut. In other words, it will give us a clear indication as to what evidence or upon what evidence the accused are likely to be convicted. And the accused will then take that stand or will go into the witness box to rebut that specific evidence. Now, the only evidence which the court seems to have accepted up to now are the confessions. Because if you look around holistically at this case, you'll see that there is no eyewitness evidence. None of the people in the house positively identified the so-called intruders. So that the evidence that we have now before that court can only be circumstantial. And of that circumstantial evidence, the most important that we have seen that the court seems to rely upon is the confession evidence, the evidence of the confessions allegedly made by the accused persons. Because you'll also recall that there was a trial within a trial, in which trial within a trial, the admissibility of those confessions was being challenged. In other words, the defense counsels were saying these confessions were not made freely and voluntarily as required by the law. But Judge Ratamokwatle thought otherwise and ruled that those confessions had been made freely and voluntarily. So that is the first step which I think the defense must embark upon when the trial resumes. Of course, there are other options, like the special entries that Mgomezulu has always used to talk about. Remember the late Tulani Mgomezulu at some stage, rose up to tell the judge that, Judge, you are biased. Unprecedented in a South African court of law. You are biased, and I'm going to make a special entry to that effect. So special entries could be another way to go. But I think this application 174 should be a good starting point for the defense. Like I've already indicated, it will give them an idea in the event that it is rejected. The court will then say there is this evidence which, has been tendered, which they have to come and, challenge somehow. We are looking forward to the trial now. There's a lot of speculation, but speculation is speculation. But I think the most important thing that happens, or that should be of concern to all of us, is not speculation. It is what is going on in the trial and the possibilities, the legal possibilities of what should happen. And this is my take this morning, that a Section 174 application should be made as soon as the trial resumes. Well, we'll see whether Mnisi will be there. I've had information that he might well not be there, but let us hope that Mnisi will be there, and then they can jointly mount this Section 174 application for the discharge of the accused. Having said that, let me thank you for watching this video, like all the other videos that you've watched in the past and that you will watch in the future, and all the subscriptions that I'm seeing flowing in. Please like and share these videos. Don't skip those ads, and have a nice Freedom Day. Thank you very much.